Good morning, everyone. Very warm welcome to this webinar this morning on stopping the row. It's going to be particularly focused around stopping rows with investors, which I'm sure some of you here are here because you've either been an investor and been on the sharp end of a row, or indeed being an entrepreneur and being on the sharp end of a row. Hopefully some of you have not yet had a row, and this will help prevent you ever having a row. So we have two speakers in addition to myself today, Alex from Gannon's and Paddy Willis, who is a highly experienced entrepreneur and VC as well. So I will let Alex introduce himself, and then Paddy, and then Alex, I'll invite you to take the stage and tell us what you have to say. So thank you very much.
Thanks very much. Yes, I'm Alex Cleanthus. I'm a solicitor and head of the litigation dispute resolution team at Gannon's Commercial Law Limited. A particular part of my my work, my focus is disputes regarding shareholders, partners, LLP members, etc.
Didn't expect you to be that quick, Alex, sorry. So, hi, I'm Paddy Willis. I'm CEO and founder of Mission Ventures, which is an organization that works with startup and challenger brands in the food and drink sector. My journey to that point was varied, and the main sort of point of qualification, I suppose, was back in 2006, I co-founded a baby food brand called Plum Baby, which was remarkably successful. And we managed to exit in our target year 5 to Darwin Private Equity. And that led me into then doing other things in the startup world, including running a charity for 5 years, which where I first met Morwenna, who very kindly came in and spoke to our startup community, and have done small investments along the way. Lost more than I think I've gained on those so far, but I'm hoping that we're going to win big with Mission Ventures. So happy to share some of my experience, both as someone who's raised money and worked with people who are raising money, and as a now effectively as an investor in a new capacity.
Alex, over to you.
Great, thanks very much, Morwenna. Let me say first, I'm only going to really talk about limited companies. There are also LLPs, limited liability partnerships, and ordinary partnerships that people can be involved in business in. They're different animals. They, in many ways, have different rules. So I'm going to limit my comments to limited companies, but a lot of what I say will go for that as well. And I'll be happy to answer questions about LLPs and partnerships at the end if people want to know how things are different. I'm intending to look more at how to avoid disputes than how to deal with them when they arise, although there's clearly an overlap, and knowing how a dispute will be dealt with if it arises, in my view, can very much prevent it from arising. And that's a lot of what I'm talking about is preventive and how to stop disputes happening rather than how to deal with them when they happen, because sometimes it's too late in those cases. You'll see what I mean in a minute. First thing I want to emphasize is the different roles of individuals, because ultimately we're talking about individuals here and the way people are relating to each other. And one of the crucial things to have in mind and really to identify clearly at the outset is the different roles that individuals can have. One person could be a director, they could be a shareholder, they could be an employee, and they could be a creditor of the company, and they could be any of those, one of those, some of those, or indeed all of those at the same time, or their role might change from time to time. And it's always absolutely essential not just to think I'm dealing with X, but X is a shareholder and a director and an employee and a creditor, and think about their different rights and responsibilities, because each of those people has different rights and responsibilities, possibly in the case of creditors, not responsibilities, just rights. For example, simple example, sometimes a hostile action might be to look to wind up a company. Well, you might think, well, he's a shareholder, he can't wind up the company because in order to wind up a company, you need a 75% vote. That's the usual rules. I'm sure many of you will know. Shareholders can wind up the company if there's a 75% majority. But what if that person is also a creditor? is owed money by the company. They may be able to wind the company up as a creditor. If they're owed more than the company can pay, and more than the liquid funds, then it may not matter that they've only got a 10% shareholding if they can wind up as a creditor. So different capacities are essential. I'm a lawyer, I make no apology, and I see disputes from the lawyer's perspective. And therefore, what I see when it gets as far as me is a dispute that has arisen. People don't tend to come to me before the dispute happens. That's my colleagues, some of whom I'm delighted to see on this call, who set the businesses up. By the time it gets to me, there's usually a dispute, and often it's too late. It's too late to avoid the dispute. And sometimes it's too late to deal with it in a way that would have been much more, much simpler and especially cheaper, and get a better result. Because so much of dealing with a dispute and avoiding a dispute is in the setup. And my absolutely key message today, the one thing I want to really get across, is that the more you can agree before a dispute arises, the less expensive and time-consuming that dispute is going to be, and indeed, the better the chance of avoiding that dispute at all. The rules, by the time you have a dispute with someone, it is too late to establish the rules for resolving that dispute, generally, because people are only going to agree what then suits them. Whereas if you can get an agreement in advance, and I can explain in a minute what I mean, it makes things so much quicker and simpler. The key then is the setup, setting the company and the business up right from the start. And the key to that is the documents. I'm a lawyer, of course I say that. It's the documents, it's the words in the documents. And the key documents are broadly the four of them. The first is the Articles of Association of the company. You're all familiar with the company's articles. They usually very boring, dry stuff that nobody ever really reads until you actually have to. The article can do a huge amount. The articles are essentially a contract between the shareholders, and there's no set statement of what they have to do. They cover certain things. You can have model articles. Again, I'm sure you're all familiar with model articles. If you set a company up at Companies House, you can tick a box and say, we'll have model articles, please. And that's a standard one-size-fits-all set of articles, although more likely it's a standard one-size-doesn't-fit-all set of articles. It's very unlikely that if you're setting up an entrepreneurial business, model articles are going to work for you. You're going to want something a lot more sophisticated and more complex, and to deal with exactly the sort of problems that can arise. The second document you're going to need is the shareholders agreement. Shareholders agreement is a private agreement between shareholders. The articles of the company are public and they are published. They're on Companies House. If you change them, you have to file the new articles. So the shareholders agreement, though, is a private arrangement, and it can cover a lot more detail and go much wider than the articles. There's really no limit to what you can do in the shareholders agreement, and I'll talk in a minute about the sort of things you're likely to want to put in there. It's usually essential to have it professionally drafted. There again is very much no one-size-fits-all shareholders agreement. Every agreement, if it's going to do its job, needs to take into account your particular circumstances, characters, individuals, desires, and the way you're intending to work. The third document, again, one many of you will be familiar with, the investor agreement. If you have professional investors, if you have angels, VCs, they are quite likely to want an investor agreement to protect their interest. It's different from a shareholder agreement often in that the investor is concerned to protect their investment, but beyond that doesn't necessarily want to get involved with who can transfer shares among their family and so on, and who can actually decide the detail of board resolutions. It's more likely to be a kind of a negative check. You're not allowed to do this or that without investor approval. There might be an investor director on the board, perhaps, that sort of thing. So you may well have an investor agreement. And the fourth document is the employment contract. As I said, individuals can also and are likely to be employees. Founders in particular are likely also to be employees. they should have an employment contract. If they're directors, then it's actually a legal requirement to have the employment contract or a statement of the terms of employment available for shareholders to look at. And the key to these documents is considering the interplay between them. They aren't standalone documents in separate silos. The Articles of Association, shareholders agreement, for example, need to work together. There are provisions which could go in one or the other. Good leaver, bad leaver provisions, which I'll come on to in a bit more detail in a minute, could go in the articles, could go in the shareholders agreement, sometimes split between the two. The vital thing is that your documents work, and they work together, and they do what you want. And from my dispute resolution perspective, they address the problem of what's going to go wrong and how it's going to be dealt with. So often, things don't go wrong. Nobody goes into business thinking that they're going to break up with their business partners, in the same way that people don't get married thinking they're going to divorce. But statistics tell us that 100% of divorces begin with marriage. And similarly, 100% of business breakups start with people going into business together. And it may work and it may not. When it works, it's fine. I am a cynic because I only see the ones that don't work. When it works, people don't need lawyers like me. They just get on with it. And if the documents say something and they want to do something different, that's fine, because you can always agree to change a contract. You can always agree to change a shareholders agreement or to waive a right or something. The documents are there essentially for when it goes wrong. If everything's right, they get put in a drawer and put away, and nobody has to haul them out and look at them. But it's vital that if you do, they're there and they work. So what particular issues are we going to want to deal with in these documents? Time is limited in this. Now I'm going to rattle through this quite briefly. I'll be happy to expand on any of these in the Q&A after, so put questions in the chat as we go along, please, if you have any. One of the key issues to consider putting in is rules for management. How is the business actually going to be managed? Now, the Articles of Association might well say there will be a minimum of 3 directors, the quorum for a directors board meeting will be 2, but that doesn't really answer the question. It doesn't actually get down into the nitty-gritty of how the business is going to be managed. Do you need a particular majority for something? Will somebody be able to veto decisions, capital expenditure over a certain amount or whatever? That sort of thing typically goes in shareholders agreements, and I'm sure most of you are familiar with seeing shareholders agreements along those lines, and indeed also, as I said, possibly in investors agreements. They will broadly say who can do what, who has the authority to do what on their own authority or with what sort of majority, what consents are needed for various steps. Do you need the consent of a certain majority? Do you need the consent of particular individuals? Do you need the consent of an investor? The more that can be decided in advance, the better it will be when there's a dispute. It may well be that one director thinks that the company shouldn't be doing this and has a fairly strong view on that. But if they've already agreed that their consent is not necessary, then it's much more difficult for them to suggest that you shouldn't do it without my agreement, because it's possible to point to the shareholder agreement and say, well, this is what we agreed. This majority can take that step. So it often heads off disputes simply by having that, and people recognizing that there are already rules for this. Another key aspect of shareholders agreements are the rights to buy and sell shares. Individuals will usually have the unfettered right to sell their shares to anybody they like. Obviously, that's often not convenient, and we don't want that. We want to know who we are going to be in business with, and often a right to buy those shares before they get sold to a third party. So rights to buy and sell shares, rights to pass them on. Now, there might, for example, be included rights to pass them on to a family member, to a family trust, basically keeping them within the family for commercial purposes, but not to a third party. Again, there's no right or wrong to this. It's just it's something to think about in advance, that you don't find that something then happens that you're not happy with. One of the major areas that comes up in this is good leaver, bad leaver provisions. Again, I'm sure everybody's come across good leaver, bad leaver provisions. There is no definition of good leaver and bad leaver that is generally applicable. It's a term that is defined for each agreement. If you say to me, what's a good leaver, what's a bad leaver, I'll say, well, show me the document and then I'll be able to tell you. Because if it's defined, there it is. And if it's not, it doesn't mean anything. There is no, as I say, again, there's no one size fits all. I once saw an agreement which had, which distinguished between a good leaver, an intermediate leaver, a bad leaver, and a very bad leaver, each of which was a defined term, and broadly, depending on the circumstances, they get away with more or less of the value of their shares. Again, that sounds funny, but actually what that shows is that people have put some real thought into the circumstances in which people will be able to take their investment if they are made redundant, or if they decide to give notice, or if they're dismissed for gross misconduct, will each have different consequences. So the more you can, again, I come back to the same point, the more you can think about this in the first place, the less likely there is to be a dispute, or the better the tools you've got to resolve it. Another area that's vital to think about in advance is restrictive covenants, post-termination restrictions, non-competes typically, and not soliciting clients, etc. Generally speaking, when we go into business, we would all like to have no restrictions on ourselves after we leave, but we would like everybody else to be restrictive and competing with us if they leave. That would be nice. Obviously, generally it doesn't work that way. You would usually have restrictive covenants that apply to everyone, but you don't know at the beginning which end of those you're going to be on. Are you going to be the leaver who would like them to be as loose and short as possible, or are you going to be remaining in the company and you want long covenants that you can enforce? When somebody's looking to leave, it may well be too late to negotiate those. So again, the time to negotiate them is at the beginning. There's no one size fits all in restrictive covenants, and the validity of them is extremely complex, and it's a topic on its own which I'm not going to go into. But the crucial point to make about restrictive covenants is that they're much less easy to enforce against employees than against shareholders. Employee covenants, an employee non-compete for more than 12 months is almost bound to be unenforceable. And indeed, 12 months itself for most employees will be too long for a non-compete. 3 months or 6 months, perhaps, if you could have a non-compete at all. For business owners, shareholders, and the same goes for LLP members and partners, you can get much longer non-competes because they've got an interest in the goodwill of the business. And that one leading case upheld a 5-year non-compete clause for a firm of solicitors in Hong Kong. So you can have quite long provisions if it's in the shareholders agreement. It could well be the case that exactly the same non-compete clause in the shareholders agreement would be upheld, whereas in an employment contract for the same person, it wouldn't be. So again, the drafting of the documents is absolutely vital. Another issue to mention and to bear in mind is one that's often misunderstood, which is quasi-partnerships. Again, I'm sure it's a term many of you have heard. I see a few people nodding. What is a quasi-partnership? There's no statutory definition of it. It's effectively been created by the court. A quasi-partnership is where there's a relationship between shareholders on the basis of mutual trust and confidence. Now, generally speaking, there is not a duty of mutual trust and confidence between shareholders, which sounds a bit odd when you say it, but generally shareholding is a commercial proposition. If I buy shares in Marks and Spencer's, I am in no relationship of mutual trust and confidence with other shareholders. And similarly, generally with even smaller limited companies. But where there is a relationship, where people have gone into it as if they were going to be in partnership, where there's an understanding, and this is crucial often, that they will all participate in management, where the idea is that the shareholders will also be actively managing the business, and typically also where there are restrictions on transfer of shares, you may well have a quasi-partnership. If I buy shares in Marks and Spencer's, nobody's expecting, and I'm not entitled to turn up at Paddington and walk into head office and say, where do I start work? Now I'm a shareholder. Again, with most limited companies, shareholding does not give you a right to be involved in management. But, when 2 or 3 friends get together, start up a small business, they each get an equal stake, they're all working in it, there could well be the idea that they are entitled to be involved. And if two of those get together and vote the third one out because they've got greater than 50%, that third one may well have a right to say, well, actually, you can't do that. You're not entitled to do that. The deal was that we all set this business up together, and I'm entitled to be involved in it. How do you avoid that argument? Well, the answer, which you'll guess by now is where I'm going to go back to, is you need to have an agreement in advance. Very often, one of the main purposes of a shareholders agreement is to make clear that there is no quasi-partnership, that a director can be voted out in certain circumstances, that their shares can be taken from them and then compensated in defined ways. Otherwise, you get into disputes. There are lots of other areas, and I'm conscious of time going on. I won't talk about more aspects. I'll come on to talk about what happens if a dispute arises. You can't always avoid disputes. You can't, sometimes they just happen. There's no way to get around them. A dispute comes up. How do you resolve it in the best way possible? Well, ultimately, the courts are there. The ultimate dispute resolution mechanism is a court. And typically, that could be an action for breach of contract or enforcement of a contract. For example, enforcement of a shareholders agreement where somebody's in breach of it, or the unfair prejudice petition or minority shareholder prejudice, which again, I see some people nodding, may well have been involved in this. If you've ever been involved in an unfair prejudice petition, I can absolutely guarantee that you never want that experience again. Unfair prejudice, I see people nodding again. Unfair prejudice petitions are an absolute nightmare. They are just the worst kind of litigation, in my view, that you can have. They are invariably very expensive. They are invariably take a long time. You'll probably take best part of a couple of years to get to a trial in one. They get down into all sorts of nasty little factual disputes and allegations and they really are an absolute nightmare, devoutly to be avoided if at all possible. They're the last thing you want to do. How do you avoid getting involved in that? Well, arbitration is one possibility. Arbitration is basically a private court. You can, in your shareholders agreement, for example, have an arbitration clause. It doesn't save a lot of the time and expense of litigation because arbitration, frankly, tends to take about as long and cost about as much as going to court, but at least it's private, which for many people will be a significant advantage. But there are better ways to resolve disputes, and the best way to resolve a dispute is to agree to settle it. Now, it's always possible to seek to negotiate a dispute, but in circumstances such as a business dispute, very often the most powerful way of resolving a dispute is mediation. In the last 10, 20 years, mediation has become much more popular. I suspect many of you have been involved in mediations. The idea of a mediation, for those who aren't familiar, is that there is a neutral individual, the mediator, whose job is not to decide the dispute. That would be an arbitrator who can actually decide what's going to happen. The job of the mediator is to encourage and assist the parties to reach a solution. And mediation is often very effective. You can't force somebody to mediate. And even if you can pretty much blackmail them into coming to a mediation, you can't actually stop them just sitting there saying nothing, staring. I've had that. People just come along and make it absolutely clear they have no intention whatsoever of resolving this dispute today. But even then, funny things happen. The mediator says, look, you're here now. You've paid for this. We may as well just talk about it. You've got nothing to lose. And people start talking and opening up, and sometimes strange things happen. The power of mediation is that the mediator can talk in confidence to each party and get an understanding of what they want and get a God's eye view of the dispute and possibly find solutions that the parties couldn't get to themselves. I'll talk a bit more about that in a minute when I talk about the soft side of settlement. Another aspect that's often put into agreements is a tiebreaker of some sort. Again, you may well have seen this in shareholders agreements. Tiebreaker clauses, for example, if the two parties can't agree, then a trusted third party, perhaps an accountant or a mutual friend, will be asked to decide the issue, or an expert will be appointed to determine the question of whatever the dispute is. My experience of these clauses is that they sound great in practice, but don't really work in principle. I mean, the idea that if two parties in a company have got a dispute and they give it to an expert, and 12 weeks later the expert gives them an answer, it's just not really practical. I mean, it doesn't work in timing terms. Even if it's much quicker and you've got a third party who's going to decide, it tends not really to resolve things, because the one who loses, whom the decision goes against, isn't happy. They're not content. There's going to be some rancor there continuing, because they had their view, the other person had their view, and it was decided against them. But why? It's generally much more, you generally get a better ongoing result if you've already provided for what's going to happen, in the sense that if the answer is, well, we're not going to spend, there's going to be no capex of more than £50,000 unless both of us agree, and one person thinks there should be and one person thinks there shouldn't, the answer is we have to both agree. And the one who wants to spend it can see on the paper they've already agreed that they won't, which generally, can't always say that, but generally they're going to be a bit more at ease with the result, that's what they can't do because they agreed that they wouldn't, rather than a third party saying, well, I've looked at it and I don't think you should. It tends to make things a little easier going forward. Not always, but I don't like tiebreaker clauses. I don't think they work very well. One aspect that people often think is going to help them in these circumstances is D&O insurance, directors and officers insurance. Usually it doesn't. D&O insurance protects directors and officers generally against liabilities to third parties. It protects them against, there could be employment disputes, it could be wrongful trading type claims, negligence claims, something like that. It generally doesn't respond and protect against disputes between shareholders. Sometimes those are framed in terms of breaches of directors' duties, and it might respond, but often, again, policies make clear that they're not there for intra-company disputes. They're there to protect directors against third parties. But the absolute first, the key thing I want to say, the key thing I said initially was try to sort out what's going to happen and resolve disputes and avoid them happening. If a dispute comes up, one of the first things to do is to try to understand the other party's position. It sounds obvious, but very often I find that clients aren't really doing that. Why is the other person upset? What actually are they upset about? Do they actually have a point? Sometimes the other side have a point. Sometimes both sides have a point and are not necessarily being unreasonable or not entirely unreasonable. It was always worth thinking about what they're upset about. Do they have a point? What are they really upset about? Are they actually upset about this particular issue that's cropped up, or is there some deeper underlying problem? Are they generally dissatisfied with the way the company's running? Do they actually want to leave and they've latched onto this as an issue? And I'm sure you can all think of examples you've seen in your careers of where what people are saying it's about isn't really what it's about. What do they actually want? What are they actually looking to achieve from this? And what are you actually looking to achieve from this? Which again is not necessarily what the actual dispute that's arisen seems to be about. And in resolving it and trying to get an agreement, if we can identify what each party actually wants, only then really can we get towards a solution that everybody's going to be able to live with. Because it may well be that what each party wants isn't incompatible. It's not necessarily a zero-sum game. That's where the mediation is so powerful. I mentioned before the God's eye view. What you often find in mediation is that the mediator who can talk to both parties say, look, what is it you actually really want out of this? Now you're arguing over a particular item, and either one of you gets it or the other does, but really what do you want? And when the parties can say to the mediator in confidence, because the mediator won't pass that on to the other party without permission, if they can say what they actually want, the resolution they're actually looking for, the mediator can often see solutions that the parties can't see and can't get to for themselves. If the parties are arguing about A, B, and C, and one of them says, look, I really, really want A, and I don't care about B and C, and the other one says, I really want B, and I don't care about A and C, it's pretty obvious that they're going to reach a solution. But if you're just negotiating directly with each other, you can't say that. You can't say, I really want this. This is what I absolutely want, because you're giving away your position. So mediation is often a very powerful way of resolving disputes. Ultimately, and again, this is the key point, it's best to have rules set out in advance in order to resolve a dispute. The rules as to what should happen and the rules of how to resolve the dispute. While I said earlier you can't be forced to mediation, the fact that it would be put in a shareholders agreement as something you should do before going to court can often make it happen and give an excuse, if you like, for it to happen. That's a brief canter through a lot of issues, and I'll be happy to speak about any of those or any more in Q&A after we've heard from the others. Thanks.
Thank you very much indeed. I'm just going to remove the pin. Right. Right, everybody. Well, thank you very much. That's fascinating and I think wise advice, which is get it written down and go to mediation if there is a dispute. This would be my summary. Is that right, Alex? so thank you. But interesting and pertinent examples and things. Paddy, do you want to turn on your mic? You, I suspect, like me, have both been an investor and a recipient of investment. So shall we start by sharing our worst war story of a row with investors?
Oh God, bring out the old laundry, isn't it? Yeah, and Alex, thanks for your points. I think before going into that, I just wanted to make the point that the word that constantly comes out at me the whole time in discussing this kind of topic is communication. Whether it's written communication in black and white about what the circumstances are in event X, clause Y is brought into play, but it's getting to a point where the founders, if there are, assuming there's more than one of them, actually are really clear what it is that they're going out to achieve. And the number of times I've seen startups where people have banded together and they've been jolly glad to find somebody that believes in their vision and that they can co-found with, and they go charging off. And the very first time anything gets documented is actually when they make their first investment or receive their first investment, and it goes into a shareholder agreement and articles. So one of the things I sort of want to return to the theme here is the clarity of communication and the respect of the human beings involved in all of this that are on both sides of the table, as founders amongst each other and investors and the two parties. Whether because too often I've seen the biggest issues being and the loss of faith in those businesses being when communication's broken down, often just for poor reporting more than anything. Not necessarily with sort of malice of forethought, but yeah, I think some of the. I mean, one of the worst cases I can remember is, fortunately, not one of my businesses, but a business that I was doing some sort of mentoring for a few years ago, where the co-founders had one of them had gone off. This is based in London. One of them had gone off to New York to sort of open up the American market for their promising sort of digitech, media tech business. And neither of them had been in business before. They both worked in the same company in the past, so they had some sort of professional affiliations. They got some early investment. And then the guy who'd gone off to New York sent a text. This is why I think so much of business is so akin to dating and marriage. She got a text to say that he'd set up a separate company in the US with the purpose of doing exactly what they were doing in America, and he felt he was better positioned to do it, and he wanted all the rights to everything they had. Now, that just kicked off a complete shitstorm, as you can imagine. The girl that I was supporting was in pieces, didn't know what to do. She was very much on the creative side rather than the business side. And I think that's a really tricky, I mean, they just didn't have robust enough, they should have spoken to Alex, I guess is the point. They should have set a real clear direction as to what they were setting out to do and what would happen in the event that they were, I mean, she had no idea that he was going to do this. I am, just as a footnote to that story, very pleased to say that I don't believe his business went anywhere, but she is a rising star of the startup tech scene here in the UK. So good luck to her. So I think it's issues where people aren't communicating with one another, which is where the rot starts in. And in the case for investors, it's often that people are chasing just give me a report, tell me what you're doing. You know, you wooed me all of those months to get me to put money into your company. I did that, and then now you don't talk to me. You know, you slept with me and you're happy to do that, but now you don't want to know me. You don't return my calls. So I think as I said, the abiding message in all of this is to bear in mind that it doesn't matter what cap you're wearing, whether you're wearing the shareholder, the director, the founder, the investor, etc. You're all human beings at the end of the day, and we all have our own foibles. Nobody likes to be caught out. Nobody likes to be made to look fool. And it's that sort of mutual respect, which I think often disappears once a transaction has been made, and people just get on with it and think, oh, okay, well, I've got the money now. I'll go back to them, and I'll probably tell them about a week before, you know, we're going to do payroll on Friday and I need more money. Where's the check? It doesn't happen. It doesn't work like that. So I think, I don't know, there are so many, I know may not really answer your question, Morwenna, but I feel there are so many sort of common threads in what I see, both as an investee and as an investor, that it really just comes down to that breakdown in human communication. You can have everything documented that you want, but as to Alex's point, you really don't want to get there. But what you should do when you do arrive there is have a clear process that you won't have anticipated every problem, but you should have a mechanism that you agreed at the start was fair. And I can think of a personal example where we had a big issue with a co-founder in one of my businesses wanting to step out, and we had a hell of a fight about how many shares he should surrender as a result of doing that. I mean, real mess, and one of the other investors had to step in to mediate. So big fan of mediation, by the way. And I often say that I'm married once but divorced twice. So my first marriage, which actually was pushed sort of really to limit, really by our startup, I have to say. But then also I've gone through a divorce in a startup where I've broken off with a co-founder, and it feels emotionally as tough as almost, I'm not quite, but almost emotionally as tough as breaking up with a loved one when all that trust you had together has broken down. So yeah, so communication is absolutely the core of identifying and preventing getting to a point where you have the horror stories.
That's really helpful. So if I say a few words, then perhaps we'll do a bit of banter between us, Paddy, of talking about some of the things that you can do to stop the row. But I did promise you my worst story. I've over the years talked to hundreds of angels, hundreds of entrepreneurs, but probably the most pertinent one is one that happened to me, which was actually it was my second entrepreneurial endeavor. The first one collapsed quite quickly because I discovered the founders had been in prison for smuggling heroin, which was another subject for another day. But do your due diligence on who you're working with. Often another problem that happens when in this exciting world we live in. But my second one, I was drawn in by the mother of a child who was at toddler group with my son, who said, let's get involved in this project. So it doesn't really matter what it was. Anyway, and then they drew in someone else who I didn't know, but quite liked. He was very much a sort of corporate person, and I was the sort of ex-city rolling around trying to work out what to do with my life. So this lady and it turned out her husband was involved, and they were very plausible, very charming, very friendly, lots of cups of coffee and inviting round to lunch. So one felt they were okay, and I got involved. Fortunately, I wasn't going to invest any cash. The other chap, who I didn't know so well, but began to sort of meet occasionally, not great conversations, and he suddenly rang up after about 4 or 5 weeks and said, have you, maybe it was even actually 2 or 3 months, I've just put some money into the company, but I'm a bit suspicious about what's happened. And I said, oh, well, I don't know you very well, but what's been going on? He said, well, they asked me to put in £25,000, and I did, but I'm suddenly a bit worried, there's no paperwork and, what's going on. And so I was like, well, we'd better sort of check this out. So we sort of asked, and he said, well, I was promised that they would put in £25,000 alongside my £25,000. So I said, well, you better actually check this has happened. So I sort of rang up and said, can I see the bank statement of this business and what's going on? And out came the bank statement to show that the chap had put his money in and they hadn't put theirs in, or they'd put in a small amount. And so this immediately caused a kerfuffle, as you can imagine. And there was some sort of reasons. They said, oh, well, we didn't actually promise we'd put in our money with you or ahead of you. We are going to put in our money, blah, blah, blah. But as you can imagine, trust collapsed immediately. And in the meantime, we'd all run around, and I think we'd even managed to get some employees and things. So we had a very exciting first phase, and sort of things were going. And suddenly there was this sort of calling, sort of, you know, being pulled up by your bootstraps, going, what on earth's going on? So, and also it was a bit worrying, to be like, is this actually dodgy, or, you know, as well as, is it just funny? So, so I, in those days, having come out of the city, felt, ring my lawyer, please be pleased to, Alex. I did ring my lawyer. So of course, what happened to me then was suddenly the clock started ticking for me to pay a lawyer. And in the meantime, you know, I'm meant to just be helping out this scenario. So, and he says, well, this could be fraud, actually. So we need to get in a fraud specialist just in case, because, you know, it might be a reportable matter if these people are fraudsters. So then I had to hire a fraud expert person to check, because of course I didn't want to be embroiled in something that became a fraudulent situation. I wanted to protect myself. And so we looked at it and we decided that it probably wasn't fraud, it was just improper. So then there was the next step was, I mean, well, of course, nobody's really working anymore because everyone's having very cross with each other. So the business stops essentially. And then we end up having a sort of we decide to have a meeting of the gentleman who put in the money, the two founders and me. Anyway, you can imagine how the guy who put the 25 grand felt, and you can imagine his reaction was pretty much to get out his fists. I mean, he was so angry. He wasn't that wealthy. To have been pulled into this situation was completely unacceptable. So we then had a very tense meeting where they tried to sort of explain why it was all okay, and I was trying to do Paddington Bear stares at the gentleman to stop him actually punching them, but rather thinking, I wish he would, except I don't believe in violence. And of course, it ended up with us two just walking away. He lost his money. I just walked off. But it was very stressful. And of course, my cost was paying that legal bill, which was irritating, to say the least. Anyway, so life moves on. We all went our way. I'm still amicable with the chap. I haven't spoken to him for years. This was all 20 years ago now, but he's, I'm sure he's gone off to carry on with his life. I think it probably scared him witless about ever playing in the entrepreneurial world again. God knows what happened to the two founders. But they certainly weren't in my life until about 5 years later, when suddenly somebody on LinkedIn started sort of pinging me and sort of just, you know, trying to talk to me, but not about anything particular. And eventually, for some reason, there was a call, and I spoke to him, and he said in the call, "Oh, do you know these two entrepreneur people?" And I was very guarded. I was like, "Well, yes." And he said, "Well, they pulled me in 2 years later, took money off me, and did the same thing again." So that's my favourite story of a row with investors that almost led to a punch up, except for my Paddington Bear stare. So so I think there's a sort of there's some morals for me in that, and the many other things I've seen. I think what you said, Paddy, about communication, that's so important. And I would be interested, Paddy, to know, have you got any good examples of sort of best practice of how you sort of set up the underpinning for the communication, so that it just so a lot of the heavy lifting is done?
Yeah, well, it's a simple discipline really of agreeing with your investors at the time of transaction that, you know, you will provide, I would say quarterly is fine, but provide a quarterly report which just details, you know, the management accounts for the business, and, you know, a sort of traffic light on what's up and what's down on your strategy. You know, you've sold them on a business plan. Now we all know that the numbers in a business plan are fanciful at best, but you know, you said something that convinced somebody to put money in the company. So just be honest with people. I mean, that's too often, and it's kind of an understandable human trait. We're all guilty of it to a degree. Is that when things aren't going well, you don't want to have to face up to it. So you kind of do a bit of an ostrich, and you sort of hope that by the time maybe you next need to confront that person in the lift, whatever, that actually things are maybe improved. but my experience throughout has always been that people, yeah, will naturally be disappointed if things haven't gone well, but they'll respect you for being open and transparent and honest with them, because actually maybe they've got the investor might have a solution or a suggestion. And actually, I think one of the things I would always recommend, it's not always viable or necessary or even desirable on the part of the investors to become investor directors, but I do think it's worth, as if it's a small loose association of investors, angel investors, rather than necessarily going through a fund, etc., is to agree, if there is particularly somebody who's maybe got the time or the inclination, possibly some sector experience, to become an observer. And that way, they obviously are party to the communication that goes on within the board. And on that point, I would say that I've seen too many cases of small businesses, often sort of, two founders and maybe a handful of staff, where actually board meeting, what is a board meeting? They never actually happen. Now, my first true experience of with Plumbaby, of proper business, if I can call it that, was we had some pretty serious investors from the outset, including the chairman of Lever Brothers and outgoing CEO of PepsiCo UK and Ireland, people like that. And they were used to kind of what a board meeting looked like. So I had to bone up pretty quickly on making sure that we had that. And so we had a really good discipline from day one of reporting, and we had a set structure that we reported against. But a lot of the businesses I see, they're just getting on with it. Thank God the money's in the account, and we can now deliver on the strategy. But they forget to tell people what they're doing. And actually, sometimes they've got amazingly good news, but even that doesn't make it through. So for me, my advice to any founder is always make sure that you have, nobody likes reporting. It's a pain in the ass, frankly. But you do need to do it. And I'm sure those investors on the call will, I think I saw a comment in early comments was, what do we do when businesses don't talk to us? Even now I get, 5-6 years on from some investments that were made by an SEIS fund into some food businesses that we put through a program at the time. Even last month, I got calls, emails from them saying, please, can you chase these entrepreneurs to go online on our platform and update the quarterly report, because we need to report to our investors. So even 6 years on, they're still having that problem. And these are, businesses that, and for the most part, are doing well. They haven't got anything to hide, but it's just something that they don't want to do. I kind of understand, you're busy, you're trying to build a business. Reporting is looking back, it's not really looking forward. But I always say, and it's not I don't think an underestimation to say that when you join in wholly shareholder agreement, you are actually effectively marrying that business for the duration of the time that you own shares. And that has to be respected by the founder. They won't be able to deliver on their plan and their vision, their goal, their why without your money. And they have to respect that you've put your hard-earned cash, or however you got it, you're putting it at risk with them, you've trusted them, and that deserves a little modicum of respect. But I said at the very beginning of all of this that we're all human beings, and human beings are very easily distracted, very good at not doing the things we don't want to do and doing the things that we do. And as I say, reporting is just that element. But if you can keep a very simple report, and my advice to angel investors is speak to one another, appoint an observer, have that person speak for the team.
Catherine, yeah, good. Sorry, for some reason I've got a different screen up. I think Catherine might be trying to say something, but Paddy, I'm just gonna pin you, okay, to the thing for a minute, because it's a bit distracting when my screen wobbles around. Good. So yes, I've got a few tips for what I think is good, because I've had relationships where we, particularly one co-founder, we did, I would say we communicated excellently with the investors. Just as I've had my disasters, I've had my excellent. And what did we do? So one was absolutely, Paddy, the quarterly report. Put it in the diary, keep notes, get a standard format report so you can just sort of cut and paste and fill it in each quarter. Will help you a lot. And my other tip would be make use of Teams and etc. Whatever, create a data room and put stuff in the data room and let people have access to it. Clearly, you sometimes have shareholders who are entitled to more than others, so you do need to think about that issue. But good communication, I think in these days, however busy we are, because of media, we have so much opportunity to communicate. There really is no excuse not to send a text, send an email, you know, jump onto Teams and do a video call with people. So that should be sort of part of your mindset. And we certainly did that with investors in the one that worked really well. And that meant when we came back for capital, we got it. Fun. If you want to be cynical about it, that's the sort of cynical reason to do it. I think you should do it because it's proper. And I also think you should do it because you will probably do other endeavours and you may want to go back to those people in the future. And if you get it wrong, you'll find they're not very interested in talking to you again. Whereas if you communicate well and fail, you'll find they'll be there for you next time.
That's a really good point. Yeah, is that point? If you've been honest with them, they'll trust you. And it may be that the news isn't great, but if you can explain, look, we didn't achieve what we said we were setting out to do, but we can see how we can get to where we want to be. Will you come with us on the journey? Then I've seen plenty of occasions where people say, okay, I wasn't planning to have to sort of put more money in for that purpose to kind of keep steady state, but I will because I trust you that you've been honest with me throughout. And it's where people miss. I mean, I know it's such a simple lesson, and I've always tried to, you know, when mentoring people and guiding people, to say, look, you know, just be honest with people. But you know, they're humans.
Yeah. My other tip at the top is always have preferably 6 months, but at least 3 months working capital, and call your investors with the thing about I'm going to need more money with either 6 or 3 months notice. Just warn them, keep them aware, because so they have time to think, because even if they do want to back you, their personal arrangements might be such that they need time to move money around. And if you give them no notice, you put them in a really tricky position. So, and indeed helping you with things, again, that 3 month, 6 month thing around things like sales pipelines, and, you know, tell people, because they often want to help. But if you don't, if you're not transparent, Paddy, I'm sure with your illustrious investors you had in Plum Baby, their ability to help you achieve things by communicating well with them, I suspect there were innumerable occasions where they made a difference that without them you couldn't have achieved what you did. So that would be my other tip. And if you don't communicate well, they tend to, my experience is investors tend to be rather passive. So if you don't ask for stuff, they'll tend to just leave you to your own devices. I did a survey last autumn, and it was really shocking what the investors told me about their relationship with the entrepreneurs they've backed. Pretty much their view was zero. The norm was pretty much zero communication. Yeah. So even if you're doing a quarterly report, you'll probably be way ahead of many other entrepreneurs. So that was still a march. And do remember that investors talk to each other.
Absolutely.
And I think they say, isn't it, a man tells somebody something bad, they tell 5 other people, but apparently women tell 50. So be extra careful of your female investors.
Yeah. That's a really good point, is that I mean, I've just, even this morning I was wanting to get in contact. So I'm actually fundraising for another startup at the moment, which I'm one of the co-founders of, and I really wanted to contact somebody, and I thought, quickly look on LinkedIn, see who knows him, and I spotted some people that I have actually been quite helpful to in the last week. So I said, oh, notice that you're connected. Do you? Whereas if you, so you're right, even if you don't necessarily know people, the world that we operate in is very small, and word will get around. You say, yeah, business is quite interesting, not sure about the entrepreneur. And as we all know on this call, it is all about the people. You know, the business, the product, everything else, the service can change, but it's really hard to change the people.
Yeah, I think that's absolutely right. Are there any other sort of tips? I think we'll go to Q&A because there's lots of questions coming in and I want to give everyone a chance to ask them. But Paddy, any other sort of tips for the top on stopping the row?
Well, it's, I mean, it comes back to this personal experience, and it's sort of, I mean, it involves investors because it has a balance, it has an impact on the cap table, but it's where it comes back to the point about co-founders, and to the points that Alex was making, have a really clear understanding of, the lever situation. If someone's going to walk away, in my book, depending on obviously when they do it and you need to have a methodology that you can go back. Now you can agree that you can tweak it and say, actually, I'm going to be more generous to you than the document allows for, but have that situation, which was really painful for us. In fact, went through twice with 2 different co-founders on different occasions. And it's just this point about understanding that you might have started with a third, but if you're going to walk away within 12 months, you're not going to end up with a third. And if you're going to walk away within 2 years, you're not going to end up with a third. And it's that point which is, and I could not believe how, in my opinion, people were blinkered on this. They couldn't see, why can't they see my point of view here? I'm going to create value for them by carrying on doing this thing. So I think it's, that's a really important mechanism, which you hopefully will never have to deploy. But if you don't have that, then inevitably other investors are going to have to get dragged in to try and help sort of mediate, resolve, etc., and possibly even in some cases buy shares. So I think it's, for me, that's sort of again, you won't mean that you won't ever have an argument about it, but having it documented in a way that you both agree or all agreed was fair at the time is a really important feature.
Yes, I think that plays very much a couple of things you said, which is, do keep accounts and take notes of things, as well as having sort of formal reporting. But if things happen, get it written down. Contemporaneous accounts, I'm sure Alex will agree, are more valuable if there is a dispute than if you have to try and remember 3 months later. And also, you're often very, when you get angry, your perspective on how you perceive something changes dramatically. So if anything, the cool hard light of looking at your own notes can help sort of lower that tension and the adrenaline pumping around you when you're so furious. So I have one other little tip, which is was something which I think is quite interesting, which is it's potentially bring in a company secretary to things like board meetings. So have an independent note taker who records what's going on, which all parties can then review, because we all know he who writes the minutes controls the record of the meeting and writes history. So that's just another little tip for the top. It's funny, I thought this amount of time would have every possible topic discussed around stopping the row, and I feel there's a whole encyclopedia of things we haven't. All we've really touched on is one of my favourite phrases, E.M. Forster, which is only connect, communicate. If you do that, you won't ever get into too much trouble. But I really do want to go to Q&A now, because we've only got half an hour.
Can I just add one? Sorry, one last tiny little thing, and it's 95% the other way, which we've been talking about, which is founders not communicating with investors. But I think also for small angel investors, I think it's also really important to understand and respect the time of the founders. I have seen too many instances where often relatively inexperienced angel investors are pounding the door the whole time, constantly asking for an update, sort of random ideas. And it's really irritating, and that's one surefire way to turn off the founders from being communicative with you. But it happens very rarely, but it's something that both sides need to be aware of.
No, that's a really good point, actually. And yes, and certainly I think you have to use your judgment as an investor, where the shareholders agreement says you have all these shareholder rights. You have to understand that if you have invested a very small sum of money, you're never going to invest again. And on top of that, you manage to distract the founders from doing their jobs by taking up too much of their time. Your ability to get them to cooperate and do what you want to do is going to be much lower. Just that sort of the law of the jungle, I'm afraid. So so understand that. And hunting in packs as investors is only so effective. Right, let's go to chat, because there's so much coming in. And I'm going to try and go right back to the beginning. So I won't say who it is, they didn't give they sent it to me privately, but quick comments from Alex and Paddy on is it actually too late to worry? Is it all about doing the documentation? Do you actually need to spend quite a lot of time talking through how you want to behave and run a company, or indeed investors, how you want to work with investors before you get into the documentation? Does anyone have a sense of how much time and what you should actually clarify before you go to documentation?
Well, sorry, my personal view on that, certainly if we're talking about the founders, they really should, even if it's just a simple letter between them where they've outlined what the shared vision is, what they're going to do around investment, what their plan would be if one of them wanted to start to kind of dial down their involvement, etc. I think you really need to have that agreed before you're starting to talking to investors. Because if nothing else, the investor might ask a question, you both give different answers, in which case probably know what the answer is going to be on the investment. So I think it's really important that you've got alignment. Again, with the fast-paced world, a startup is often not happening, but it should, and that's what I always recommend people to do is to get that alignment before they start talking to lawyers or investors.
Very good, thank you. Alex, have you got any sort of because we've got so little time, but sort of very quick bites of an example of somebody who hadn't really talked to you before and somebody who had, and what that does to the bill you charge them?
Well, I look at, I have many examples of people who hadn't talked to us before because they tend to be my clients, or otherwise known as the claimant or the defendant. The key is, I look on getting a shareholders agreement and maybe the surrounding documents in many ways as an insurance policy. You might spend £5,000 or whatever on getting a good shareholders agreement done. I know at the beginning your time is precious, every penny is precious. But it's an insurance policy. That 5,000 could save you 500,000 later on. It can save disputes, as Manuela and Paddy have said. If you know what the answer is going to be, you may well be able to avoid those disputes. You can always change your mind. The other thing I would say, and I very much agree with what Paddy just said about deciding as much as you can before you go to the lawyers. What will happen when you go to the lawyer is you won't be able to fudge things. What will happen in these circumstances? What do you want me to write down? We can draft pretty much anything you want, but you have to tell us what it is that you want. And the other thing I would say very briefly is get the documents actually signed. The number of times somebody's come to me and say, well, we've got a shareholders agreement. And I say, great, where is it? And they say, well, we didn't actually get it signed. It's here in a pretty final draft, and it kind of drifted a bit, but can't we use this as evidence of what we actually agreed? And I say no for two reasons. Firstly, because you didn't actually agree it, you didn't sign it. And secondly, it could just as easily be evidence of what you failed to agree. Why didn't you get it signed? Presumably because you hadn't quite agreed it. So it's vital to actually get on and get it done, in my view.
That's very wise advice. Paddy, we had a question about, have you ever had a situation where it's sort of been a board shareholder dispute rather than a founder shareholder dispute, where maybe there've been non-execs on the board, where it's become a bit more complicated than just founders versus investors?
Oh gosh, nothing that immediately springs to mind. That's not to say it hasn't happened, but it's probably been shut away in some box to be forgotten about forever, as long as I can. No, I can't think of an incident where. Well, yeah. Other than in a very small business where there were, four people around the table, one of whom was an investor and the other three were co-founders, and that was where we got into this sort of troubled water of trying to untangle the original founding partnership, and that's where the NED had to get involved, and became. Fortunately, he was on my side, but it became quite tricky, and it was uncomfortable for everybody involved, but. That's just because it became quite emotional, and I think you made that point when it's people see a red mist and it becomes personal rather than actually this is just a decision that they had taken, wanting to change what they were doing, and then I was simply standing up for my rights and they didn't like it. So, but yeah, so I can't think of anything else beyond that.
Okay, thank you. Yes, I think it is relevant, particularly as companies grow and get bigger, that the sort of this idea of the founders and the investors. It feels very quite startup and small, that very quickly that other people get embroiled, and that's why so many NEDs want D&O cover. Though Alex's relevant point is that it may not be worth the paper it's written on for this purpose is interesting. We've had some good questions around sort of enforcement if you're a minority. So Alex, just very quickly, in simple terms, if you have 1%, 0.5%, 0.1% of a company, in reality, what can you enforce? How do you do it? And or do you just have to take it on the nose?
I've seen a couple of questions along these lines and several mentions of quarterly reports, which Paddy was talking about earlier. When you buy a car, one question you look at is, can you afford the car? You buy a car you can afford, but you also have to be able to afford the insurance, the maintenance, new tyres for it, etc. And there's no point buying a car you can't afford to maintain. Similarly, one of the things you need to consider, I think, when you put in an investment is whether that you'll be able to afford to enforce what you need to enforce. So if getting quarterly reports is vital to you, how are you going to enforce it? When I often am asked to look at draft agreements, typically for sort of the dispute resolution clauses and so on, And whenever I read an agreement with my cynical disputes hat cap on, I think whenever it says the parties will do this or the parties will do that, I always think, what if they don't? How are we actually going to enforce this? Now, say you've got a shareholders agreement that says the directors will provide quarterly reports. What's the remedy if they don't? Well, you could, as a party to that agreement, go to court to seek an injunction to get a court order that they do. And you'd probably get it, because enforcing agreements, that's what the courts do. Are you actually going to do that? You could draft it. You could draft something that says the directors will provide quarterly report to the shareholders, and if they fail to do so, then they will each transfer 1% of their shares to the investor. That might concentrate their minds. I've never actually seen that clause drafted, but I can't see any reason why that shouldn't work. So you always need to think about how you're going to enforce something. It is a problem. It is an issue. Yes, enforcement is always something to think about. Is provision of the quarterly reports the only issue? Again, as I said, are there underlying issues? But yeah, enforcement is definitely always something to consider. It's a big topic. I can't go into talk about.
Alex, I love that idea of putting something in the shareholders agreement which is has quite a blunt instrument, because of course you can always waive it.
Of course.
Think, but yeah, wise. I'm going to go away and think about that. We've had a question about if there's a 50-50 deadlock, how do you deal with it? Now, I'm going to slightly guess it's probably go to mediation, isn't it? But perhaps Paddy first. Again, quite quick comments, please, because time is short. But
well, yes, and I guess that's the ultimate destination. I guess it depends slightly what the deadlock's around, but I mean, the other alternative, of course, is to have maybe an independent director who has 1%, 2%, whatever the business, and that means that at least you've got a situation where they have to side with somebody. Who that person is and how you decide that they're fairly appointed in terms of they're not biased towards one person or the other, but even then their pitch situation might change over time.
Thank you. Alex, any quick?
Yeah, the 50-50 is the ultimate legal nightmare. Paddy's solution is great if you set it up in advance and then you don't have a 50-50 situation. You've got a 49-49-2 situation. There is no, unless you provided for it in advance, there just isn't a tiebreaker. You can try mediating, absolutely, but if you can't get an agreement that way, you still haven't got an agreement. You get absolute paralysis. One director says to the other, "You're fired." The second one says, "Well, you haven't actually got any authority to fire me because that needs a board decision and it's 50-50. If you've got no dispute resolution mechanism involved, it's almost impossible to know what to do. Sometimes you go to creditors and try to get them to suggest winding up the company. You can't even wind up the company often. Even if you get a deadlock situation, a simple deadlock isn't actually grounds for one to say to the court, "Look, this should be wound up on just and equitable grounds." If you can't point to something the other person's done wrong, the court will say, "Well, hang on a minute, this is the way you set the company up. You set it up as a 50-50 company. You set it up that there's no solution in this situation. Sorry." And it is an intractable nightmare. The people who absolutely most need a shareholders agreement are two 50-50 directors and shareholders. No question at all.
Thank you. That's right. Something that I've found has been working well in more recent years is for a company to have a sort of independent friend. It might be it might be one of the investors. It might be just somebody who both the key parties trust, and actually keep them as an independent party, so they have enough knowledge of what's going on that if they're called in, they're not going to be completely new to it. But crucially, you do not tell them all the secrets, and you do not ring up and whinge about somebody to them, so that if you need an independent person, you can call on them rather than having to pay for a mediator. So that's one idea that might be helpful to some people, because if everyone agrees that is the independent person or the Mackenzie friend or whatever you want to call it, there's no reason you can't have someone like that. And it might be an interesting job for some people who might like to do it. So that's a thought. So we've got some more things coming through, which is sort of how do you, Paddy, I think particularly this is probably you, how do you, if founders are not really telling you anything, because they feel it's very secret. And we all know that there are a very few companies really are very secret, but most little companies, actually, it doesn't need to be quite as secret as the founders think. How do you persuade them or get them into a position where they do start communicating better? Are there any tactics where you can sort of get them to start opening up and realizing that they should trust you to?
Yeah, I think where I've seen it work a few times is where, inevitably in most situations, young companies will need further working capital. And it's, I think it's not unreasonable as an investor, excuse me, to make it clear that your checkbook is closed until such time as you get regular updates on the progress of the business. Now, again, and I've seen in some of the comments in the chat, it is a big issue for people, and it's there is no easy, simple solution to it. But I think if founders are mindful of the fact that how difficult it probably was for them to get funding in the first place, and that the idea if their existing investors are not following on, that's not always a very good sign. So how do they avoid that situation? And if it is as simple as giving a one-page report or just some systematic timetabled update, then fine. That could be the way. It could be a way through.
Yeah, very interesting work. I would say also perhaps one of the things is do the old-fashioned thing, which is offer to buy them lunch. Talk to them, just without an agenda. Just give yourselves a chance to get to know each other. And I think particularly if anyone's been doing anything during lockdown, yes, we're coping really well on Zoom, and I'm hearing, thankfully, that investors are investing via sort of Zoom related situations, but it does mean we don't actually get to know each other, and all that subconscious stuff you get when you actually sit in front of somebody, and if that's missing, it's much harder to, whatever your legal rights, to get people to behave. So yeah, get them to like you. I think certainly I know what I see evidence is if angels who make an effort to be liked by the entrepreneurs tend to have a much greater access to pretty much everything.
Yeah, which is one of the reasons I stopped watching Dragon's Den about 8 years ago. It does my head in that there's this sort of charade that has to be played out. That's if you've got money, you have to be tough, and absolutely not that. Yeah,
I mean, I do know. Hopefully, the angels on the call will agree with me, but most angels do this because they authentically want to help. They want to, they want to have fun. They want to enjoy it. They want to give back. It is not simply about making a return. They could go to the stock market or Bitcoin or Tesla or something if they just wanted to stack loads of money quickly. So bear that in mind, that they are nice human beings, really. The mere fact they're there in your life. Good, interesting question from James about the equity crowdfunding platform. So, of course, in some ways, we arguably either really or infer that they're going to have these wonderful companies that are much better, perhaps, than a company not on the platform. And they're having difficulty forcing company so more than 33%, James says, of getting the companies actually to report via the platform systems. So James is saying, what should the platforms do? So I suppose this slightly translates across to networks, indeed fund managers, EIS fund managers, many others who sit as an intermediary effectively between the investor and the entrepreneur. Perhaps Paddy first, and Alex, if you've got anything to say.
Yeah, that just got me thinking. Maybe you could have some kind of equivalent of Trustpilot on the platform, which, according to that business and its directors, how well do they interact with their backers? I mean, obviously, you can see comments on those platforms where people are asking questions, and maybe you'll quite often see that there's no answer for months. But I think an ability for, I don't know, I mean, it's probably not in the interests of the crowdfunding platforms, to be fair, but that would be a neat solution, would be if somebody could introduce some kind of vetting that you could give a star rating to a company for how it, not necessarily how it's performing financially or in business terms, but actually how it's behaving as, because a lot of people investing on those platforms are quite new to the situation. So that's my little idea.
Okay, Trustpilot for Crowdcube. Okay, yeah. Alex, any very quick tips? Because again, we've only got 12 minutes. Oh no.
The suggestion that, oh well, if it's in the shareholder agreement, you can go to court and get an injunction against them is a lovely theoretical idea, but not really something that happens in the real world. I know Chris's response to that in the chat. He said, founders who forget are far less likely to get follow-on funding, but do they learn? Typically, the organised people do it. Absolutely right. It's really a soft solution to that. You have to try to persuade people that it's in their interest to do so. It's not really one that the lawyers have got an answer to, I'm afraid.
Oh, good. Here's a jolly question. What do you do with investors who behave like social media trolls?
Not sure I understand the question. What are they doing as a social media troll?
I presume what they're doing is either bugging the company or being rude about the company.
Well, got to ask the question: why are they doing that? Is it because they haven't heard a bloody thing out of you all year? But well, communication. Why, back to the point that Alex raised. What are people really upset about? It's probably not. It's not. There's probably a lot of reasons that Donald Trump was upset about stuff, but eventually probably go back to his childhood. So you can overanalyze it, but what is it? Why are they upset? And reach out. If it's very public like that, then the founder's got a very good reason to want to go back to them and say, hey, I noticed you were making this comment. Obviously concerned. Can we have lunch? Can I talk to you about it?
Good, thank you. And Alex, I suspect you've got quite a lot to say about this. If somebody is actually saying
a little, I noticed that James's question goes on to say too many claims of scam or fraud from people who lose money. So I think James is particularly thinking about people lose money as happens often, unfortunately sometimes, and they say, oh, it's a scam, it's a fraud. The legal answer, yes, you can sue them for defamation. Again, that's a lovely theoretical legal answer. It's not really likely to help you much, and frankly, you're likely to end up with a Streisand effect, where simply taking the action publicises the allegations much more widely than the audience they would have got anyway. There isn't really a simple legal answer to that. Probably try to communicate, but otherwise ignore them and hope they go away is likely to be your best solution. And communicate with the audience for those. The audience for those is likely to be the other investors. So you're not going to persuade the troll that they're wrong, but you might be able to talk to the other investors and explain what's happened and say, yes, we have lost some money. I understand you're angry about that as well, but this is why. This is what we're doing about it, and communicate.
Yeah, I would say we had one situation in the company I set up where we had a commentator who just, as far as I could work out, probably being a bit unkind, but 3 a.m, drank a bottle of whiskey, and at 4 a.m. started writing about stuff. And they would write really abusive, but actually really inaccurate stuff. But I also knew they just loved the sound of their own voice and the idea that anyone was listening to them. So in fact, how I dealt with that one was I would craft a quite formal, quite pleasant reply going, just to inform you that you are incorrect on all these points, in full knowledge that they would post my response. And I did it quite deliberately, because what I wanted was when somebody looked through that stuff, rather than seeing no response to these accusations, it was just a very calm, you're wrong here, thank you very much, goodbye. And it always got posted, and job done, as far as I was concerned, because now on record, if anyone looks, there is my response. So that is something, but I'm quite experienced. So if you're not experienced in that, I would definitely say, before you act in that way, definitely talk to a lawyer, because not everyone will be have the same experience as me. And you have to be very careful. Be very careful about counterclaims and things if you do want to respond, because you can find yourself being in a worse position by doing the response if you're not very careful. Okay, let's see if there's anything more. So this is a good one that's come in. What advice for investors do you have, Paddy and Alex, for if they want to become NEDs? Do they prevent the problems, or do you, is this a great comment, or do you unwittingly end up on the dark side if you accept it?
So becoming an NED after investment,
Yeah.
so it wasn't premeditated at the time. Well, I guess the question is why they, that suggests maybe they're concerned about, well, there could be several reasons. One is it's actually quite a sexy company and they want to be able to say, I'm director of this business. It could be that they are concerned about how it's going and they want to be more directly involved. I think if it's in my experience, most founders are reluctant to have more people on as serving as directors than they really absolutely have to. Perfectly happy to have advisory board. Now that's the other thing which we haven't touched on, which I appreciate is usually more to do with the business rather than necessarily its jurisdiction, etc. But I would say they would have to make the case. You know, is there something they're going to deliver? If they've got experience, is it in the sector? Is it in, you know, in business in general, the industry, that will deliver more value? And also, don't forget that, of course, there are responsibilities that come with being a director.
The responsibilities are absolutely, and one of the key ones of those is conflict of interest. If you're a director of the company, even if it's in terms of directors' duties and responsibilities, there is no difference between an executive and a non-executive director. You don't get a lighter ride because you're an NED. As a non-executive director, you have a number of duties to the company, fiduciary duties, including duties concerning conflict of interest. And the law will say that if you are a director and an investor, as a director, you are obliged to put the company's interest above your own and above those of the investment that you represent. And people can then quite get into difficulty if they're also a director of the investor, because they have duties to the investor as well. But primarily, if you're a director of a company, your duty is to the company. Your first duty is to the company, and it can actually sometimes be quite uncomfortable if you are a director in those circumstances. You may be better off as an observer. So I think was it you, Paddy, suggested earlier. Know, as Paddy just said, know exactly why you're doing it, what it's for, and make sure everybody else understands it as well.
Thank you, Alex. I'm going to ask a very quick question, because I think it's often something people don't realise. How can you end up being a director without being a director at Companies House? And you'll understand why I'm asking the question, to lead people. Companies
House is a register of directors. And people often think that it's not like the land registry. At the land registry, the person who is registered as the owner of the land is the owner of the land. Maybe they shouldn't be, but that's a different question. Companies House is merely meant to reflect the reality. So if somebody is a director, they are a director, even if there's been a failure of registration. Similarly, what we often see is that somebody who's in effective control of the company wants to get rid of somebody, so they file a notice at Companies House saying they've resigned as a director, but they haven't. And we often have a situation where we say this notice is simply untrue. This person hasn't resigned as a director. And if they haven't resigned as a director and they haven't been formally removed, they are still a director, even if Companies House says they aren't. So Companies House can be wrong. And the question is what the facts actually are. Does that answer the question?
Yes, and my understanding is that if you are directing the actions of the company, even if you have not been
right. Shadow director.
You can be a shadow director.
Yeah. Right. Shadow director is often misunderstood. Okay, quick 10 seconds on that. People often say a shadow director is not somebody who behaves like a director. A shadow director is a person in accordance with whose directions the whole board or majority of the board is accustomed to act. So effectively the puppet master pulling the strings of the company. Is not somebody who gets themselves involved and sort of behaves like a director. They might get some duties because of their role and so on, but a shadow director who can be liable for things like fraudulent trading, wrongful trading, etc., and broadly owns the same duties as director, is the puppet master behind the strings who can control the board and effectively controls the company.
And so even if you're not a shareholder, but you have undue influence over the situation for some reason, and are not formally a director of the company, you could still be a shadow director.
If you effectively control the company by controlling the board, yes. If you just are involved, then there's no immediate route to liability. I mean, if you're sometimes senior employees, for example, will have fiduciary duties to the company above those of the usual employee. It will depend very much on the facts, but there is no category of person. There's no legal category of person along the lines that you're suggesting.
Okay, so there we go. I think that's helpful, but that's often an area I see people are very muddled. Something I would just mention on that is when it comes to things like to Rouse, be very careful about having entrepreneurs who are, if you're a director and an employee and a shareholder, you can have quite complicated things about removing people, because you can't just remove from one or the other. And certainly I know of a situation where there is a co-founder who about 20 years ago, they would have liked them to leave. I think arguably they would have liked to go too, but they know how strong their position is. And actually because they've got an employment contract as well as a shareholding and a directorship, it's sort of impossible. so they've just been sort of gently downgraded, but it's not ideal, and it paralyzes the company to at least an extent. So we've only got 1 minute left, and there's still a couple of questions. I'm just going to check if there's anything that can be answered very quickly. Oh, thank you, Nigel, for your comments. So wonderful kind comments, Nigel. But very quickly, in a minute, Andrew's asked about, should you sort of punish entrepreneurs by doing a down round, you know, if they've not met their targets when they next need money? Do you think that's wise, Paddy?
No, I think down round is only really applicable if the performance is such that the market no longer merits the price. I don't think you can do it and also you then got to bring all the other shareholders with you and say, well, we're not going to do it at £10 a share, we're going to do it at £8 a share because you've been naughty boys and girls. I think it comes back to people being less likely, you know, inferring or saying outright, I'm less likely to invest if you don't keep me up to date with what's going on. In which case it may be harder for them to raise money, in which case it might end up being a down round if they're having to try and squeeze in to meet a cash runway. Thank
you. And Alex, I'm going to give you the last word on this, because from a legal perspective, can you legally pin non-performance to a down round? I can see why morally you may feel it's the discussion you should have, but legally, are there any issues if you try that one?
My first question would be, what do the documents say? What does the shareholders agreement say? What's the investor agreement say? If it allows you to, then you can. Probably it doesn't say anything, and it's going to be a question of whether you want it. That will be a commercial decision. I probably wouldn't have much to add to what Paddy says. Unless the investor is obliged to put more money in at a certain level, it's going to be their decision whether to do so or not.
So the legal message is, don't promise a new round of investment without conditions if you want conditions in.
Absolutely.
Okay, good.
Then you probably wouldn't anyway.
Good. Well, we've hit is it the bottom of the hour? They now say it's 11:30, so it's time to finish. I'd like to thank you very much, everyone, for joining us. I hope you've enjoyed it. We are going to be recording it, so we will let it be let loose on the internet once we've just checked it for editing and stuff. But otherwise, good luck, everybody. Hopefully, if you'd like to do more of these, do ping me an email. And one very last thing is, I've just set up something called the Funding Index, which is funding-index.com. The idea is that we're going to capture the national need for funding so that we can actually see how big the issue is, and hopefully then start changing the world and making it a better place for entrepreneurs who need to raise capital. It's for debt and grants and equity need. So if you've got a need, or you know someone who does, please send them to www.funding-index.com and ask if, for the greater good, they could fill in their funding need. And we're at about just under 600 million we've identified already. It'd be nice if we could get it to billions. So please help us. Thank you very much and have a great day, everyone. See ya.